Today in this video I will cover short topics that can come for short notes or situational questions. So let's begin. First topic for today's video is trade secrets. What if your method of doing your business, you're handling your business is leaked? Someone comes to know about your management and on what basis you are doing your business, then you will feel disappointed, hurted, and you will be afraid that the profits you're gaining from your business is now shifted to someone else if that person is using that information that was leaked from your company. Okay, so maintaining that information is very crucial to maintain your business. So what are this information can be about anything, any process, any formula, recipe, any method, marketing strategies, your investor, who are the persons who are supplying to your businesses, then the customer list. Okay, everything comes under trade secrets. Trade secrets are confidential information and it's related to business and that provides a competitive advantage to your company. This is the information which you keep secret from the public and your rival competitors. Trade secret plays an essential role in industries where unique business strategies, innovations, or processes are crucial to gaining and maintaining a competitive edge. Protecting your trade secrets means protecting your business, that business which makes you stand out in the crowd from other similar business in the market. Trade secrets means and confidential information that is valuable to your business and the information you have kept concealed from your rival parties. Trade secrets is different from other IPs like patents and trademarks because in trademarks and patents you have to disclose to the registering authority what it looks like and what is actual. But in trade secret you don't reveal your information but you seek protection from the authorities. How long you can protect your trade secret? You are protecting your business unique identity. The moment your valuable information is leaked in the public or being known to the third party or your rival, the protection comes to an end. In India, there is no specified law that protects the trade secrets, but under Contract Act IPCs, we protect the trade secrets. When we recruit any employees, the employer require employees to sign the confidentiality agreements agreeing not to disclose any information that is owned by the employer. Law says that a prime duty to maintain and to protect the trade secret lies on the owner of the business and the employer. They have to take efforts in maintaining this valuable information. For this, they can make their employees sign NDA, the non-disclosure agreements. Then they have to do internal security measures, for example, biometric log, or they can keep this information in high security. Legal remedies available in case of the breach of information is under a contract act. We can sue for the breach of contract, or in IPC we can file for misappropriation or breach of trust. Even under the IT Act 2000, we have the opportunity to file a case for data theft or cybercrime against the rival company. The next topic is geographical indications. What is meant by geographical indications? What if I give you a game to play that to identify a food item based on their states? If I say Rasgulla, then you will answer West Bengal. If I say Paitani silk sari, then you will say it belongs to Maharashtra. Okay, so this GI term is used to denote the relationship between the product and the place of its origin. Geographical indications, shortly we can call as GI. These are the signs used to indicate that a product comes from a specific region and has unique qualities or characteristics due to that region's environment, culture, and craftsmanship. So when a product gets identified based on their location and its quality, government gives them a GI tag. The tag is the sign, a mark that is helping the customers to distinguish products by highlighting their origin and ensuring that the customers are purchasing authentic and high quality goods. GI tags are given on the products that have a specific geographic origin and possess qualities. It gives the product the reputation and that belongs to a certain region. So the region is known by the product and the product is known by the region. For example, Vasai is famous for bananas. Nashik is famous for grapes. So the place is known by the product, and the product is named after its place of origin. Geographical indications are typically associated with agricultural products, foodstuffs, and handicrafts, especially. GI enhances the value of the product. It highlights its association with a specific location, and it assures the customers regarding the quality and the authenticity of the product that they are purchasing the original item. When a product contains a GI tag, it protects the reputation of the product and the producers, and it avoids the unauthorized use of the name or imitation by others. GI tags helps to minimize the risk of counterfeiting by the manufacturers, which are the unauthorized users. Geographical indications promote regional economical development. Local manufacturers can now sell their business throughout India and also worldwide. Some common examples of GI are the Kanjivaram silk saree. The Kanjivaram is a region in Tamil Nadu which is famous for its silk sarees in South India. In short, we can say that GI establishes a link between the product and its original place of production. The question is when GI cannot be registered. Under some circumstances, GI cannot be registered. And what are they? One by one, I will tell you. A tag that is likely to deceive or confuse people. If a tag contains scandalous or obscene matter. If a mark is likely to hurt religious sentiments of people, it can't be registered. If it is falsely represented by a person claiming goods originated in another region, then also it can't be registered. Any indication that has a generic name, it cannot be registered. Who is the authorized user? An authorized user is a person who claims to be the producer of the goods in respect of which the GI has been registered. And when he wants to register for that GI, he also has to file the form for authorized user that he has to submit to the registrar and pay the fees. Who is the registered proprietor of GI? Any association of person or the producers or an organization, authority under law, who wants to register the GI for some goods from that locality. And he has to enter in the register his name as an authorized user for the concerned GI he is applying for. How is GI registered? Registration of GI involves a lengthy process. GI is governed under the Geographical Indications Registration and Protection Act, which was enacted in the year 1999. So, under Section 11 of this Act, any individual or an organization, any authority, manufacturer, or a person has interest in the GI can apply for the registration of GI by filing an application with the GI registry in the Chennai. In that application, the applicant has to fill his basic information like his name, his address, the locality for which he is applying a GI, the nature and the map of the territory or the locality or the region where GI tag on the product he is concerned for. Along with the form, he has to submit a map of the territory highlighting the area, the location, and he has to submit the prescribed amount to the registrar. After filing the application, it goes with the registrar, and the registrar do a scrutiny of that form. He does a kind of an examination of that form. After examining, two scenarios arise. First scenario is where there are objections raised by the examiner, and the second where there is no objection and the application gets accepted. So let's see one by one. First scenario we will see now. In the first scenario, there are objections raised by the examiner, and in case if any objection is raised, so the registrar will send an examination report to the applicant, and now the applicant has to reply to the examination report within 1 month receiving the examination report. If he doesn't reply to the report within 1 month, he gets extended time of 1 month again, and if he fails to reply to the examination report, means total he has got 2 months time to reply. But if he doesn't replies within that 2 months, then the application gets abandoned. And if he replies within that 1 month, then the application proposed to be accepted, now the examiner will call the applicant and he will call him to support his claim, to give him evidences in support of his claim that why his application should not be rejected. So if the hearing is successful, then the application gets accepted, and if the hearing is not successful, then the application gets refused. So this first scenario is completed where there were objection raised by the examiner. Now we will let's see what in case if the application gets accepted without any objection raised by the examiner. When the application gets accepted by the examiner, then he proceeds to publish or advertise that application in their GI journal that is published online on their official websites. And under section 13, it is published in their publication under their journal, and for it remains there for 3 months. Okay, so 3 months waiting period is compulsory, and in that 3 months period, if anyone wants to file an opposition against the application, then he or she, at any person, even a person from the common public, can file this opposition if he thinks that the proposed GI application should not be accepted or should not be registered, because he feels that there is already a similar GI already registered. So in that 3 months period, if someone is opposing, then he should send the opposition notice to the registrar, and when the registrar receives this notice, he shall forward it to the applicant. Now the applicant has 2 months. In this 2 months, he has to file a counter statement against the opposition notice, and he has to submit this counter statement to the registrar. The registrar will now call both the parties and conduct a hearing, and the parties have to submit evidences supporting their claim. If the hearing is successful, then the GI gets registered, and if the hearing is not successful, then the GI application gets rejected. If any party is not satisfied with the registrar's decision, he gets an opportunity to file an appeal with the Intellectual Property Appellate Board within 2 months. Now, if a person wishes to file as an authorized user, he has to file the form for authorized user under section 17 of this act. And this application he has to submit to the registrar in writing, and he has to pay the prescribed amount. Once all these things are done, your GI application accepted and gets registered under section 18, and once it is get registered, it is valid up to 10 years. If any person means who from that organization or that group is filing for its registration can renew that GI, and for this they have 6 months before their expiry. So means 10 years time is given, so I have to file before 10 years, means 6 months before 10 years are completed. So that that will be helpful for me to renew my GI application. And if I fail to renew my GI in 6 months, I will be given time for restoration of the GI tag, which will be for between 12 months, means 1 year time I'm getting to renew my GI tag. But if again I am failing to restore in that time, then my GI tag is lost. Once GI is registered, then GI becomes the collective mark owned by that community and that locality. It promotes the local culture and heritage. It protects the traditional knowledge. Benefits of registration is that in case of infringement, I can show I have that certificate of registration, I am the authorized user, and this person has violated my rights, so I can take an action for infringement. This benefit is given under section 20, and section 21 says that what right I will be get after I register. Then I get the exclusive right to use my GI and to exclude others from making an unauthorized use of my GI that I am applying on the products that I'm selling. I get the legal reliefs. I get protection to be called as the authorized user, and I can take action in case of infringement. The person who has applied for registration now gets the registration certificate, and the certificate will serve as a prima facie evidence showing his authorized user and ownership. Section 24 says that a GI cannot be assigned or transferred to any person. Offenses and remedies in GI. Infringement can be caused by the use of GI on such goods, which indicates that such goods originated in a place, but in reality, it's some other place. Under the Act, it says that infringement is done by any person whoever is not an authorized user and he uses the GI. And second, a person who is using the GI tag for unfair competition, whoever misrepresents GI product and locality, whoever falsely applies any GI and tampers the origin of the good, then such person shall be punishable for 6 months to 3 years in jail, and they shall also be liable to pay fine ranging from 50,000 to 2 lakh fines. And if once they are being arrested and again second time they are arrested, then the punishment will be for 1 year to 3 year in jail, or fine that is increased this time 1 lakh to 2 lakh fines. Remedies granted for GI are of two types: civil remedies and the criminal remedies. In civil remedies, the person can seek for injunction. Injunction can be temporary. Injunction means while the case is pending, so that time a person can ask for a temporary injunction. And also, when the case ends, he can seek for a permanent injunction against the unauthorized user, or he can ask for damages or compensation or accounts of profit that the rival person has gained by selling their product. Then he can ask that to deliver all that infringed goods and to destruct these goods. Next topic is industrial designs. So in India, industrial designs are governed by the Designs Act enacted in the 2000. Any design that is attractive and unique and it feels appealing to the customer, and so that only this is the main reason he purchases a product or some commodity, this design is called as industrial design. So industrial design refers to the aesthetic aspect of an item, which can include the shape, configuration, pattern, or ornamentation of a product. Design is what makes the product visually appealing, distinct from other similar products in the market. And this protection given to the industrial designs aims to preserve the uniqueness of the product and to avoid unauthorized users from copying them, so that the original creators of this design can derive the monetary benefits by using these designs. So industrial design is the appearance of a material or an item. It focuses on how a product looks and not how the product functions. Industrial designs are critical in industries where the look of a product plays a significant role in attracting consumers and establishing brand identity. If I make a stationary item look more attractive, I can have more consumer as compared to the other stationary items manufactured by the other businessmen. This helps me in gaining monetary benefit, and also I am being recognized as an trustworthy person, and also for the creativity I am using to designing that stationary items. As long as I am making my items, my products look more appealing and attractive, I am maintaining the consumer interest in my products. Designs can include any shape, color, pattern, or any combination of colors or shapes that makes my product appealing to the eyes of the customers, and it distinguishes my product from other similar products in the market. First question is, what designs are prohibited from register? Under section 4, this all grounds are given that in what scenarios design cannot be allowed to register. If a design is already published in India or outside India, if the design is not appealing to the eyes, if the design is not new and original, if the design contains some obscene or scandalous matter, and if the design is non distinguishable from the known design, then such designs are prohibited from registration. Essential requirements for registering a designs. A design should be new, original, means it should be non-obvious. The design should be applicable to the functional article. It should be physical on the finished article. It should be different from the known design, and it should not contain any scandalous or obscene matter. The design should be appealing to the eye. It should not be disclosed to the public by publication prior to the filing date of application, and the design should not be contrary to the public order or public morality. Who can apply for registration? Any person or a legal representative of that person or any assignee can apply separately or jointly. Any firm, partnership, and a body corporate can also apply for registration. Application can also be filed through an agent. The person who is claiming that he is the creator of that design can apply for the registration. Procedure for registration. As per Section 5, any person who claims that the designs belongs to him can make an application for registration in the prescribed manner, and he has to submit some fees in the timeline. This application has to be submitted to the controller. If the application consists of more than one design that are being proposed to be registered, then each design should be registered separately. And after the application moves forward, it receives the application number. Then it is examined by the examiner. He will scrutinize the application, the design, and if he feels that it contains some objection, then he will send a report. Then, within 3 months, the applicant has to reply to this objection. If all the objections that have been raised are being cleared by the applicant, then the authorities under this act, means like the registrar or the controller, these persons have to accept that application. And under Section 7, the controller has to publish this designs, means this application for registration of this design, in their online official website, which is open for public. And when it is open for the public, it doesn't receives any opposition, then the application gets accepted and it's get registration, and the applicant is granted a registration certificate under Section 9 by the controller, and the design gets registered, and the date of that registration is to be mentioned as the date when he has filed the application. What is the register of a design? The register of a design means it is like a book. It a registrar where the controller is maintaining the design, then the design numbers, then on which the application has been received, name and address to the person who they have given the registration certificate. Then if there is an assignment and transmission of registered design, all this information they are keeping in one register, that book that is known as the register of design. The cancellation of registration. Design once get registered is valid for 10 years, and it is renewed again for 5 years. For that I have to file a renewal application and along with some prescribed fees. But under some circumstances, registration for that design can get cancelled. So registration can be cancelled anytime. Any interested party or a third party can file an application for cancellation of that design, and along with that application he has to pay certain amount on, and on some grounds this registration can be cancelled. These grounds are if the design has been previously registered in India, if the design is published in India or outside India prior the date of registration, if the design is not eligible for protection or not registerable, then the design is not new or original, or the applicant can also raise the ground that the person whom this registration for this design is granted has obtained this registration by fraudulent means, and his design is a copy of some original design. Infringement and remedy. Infringement of designs means piracy of registered design, because when a person or the creator of this design gets registered, he is said to have the copyright over his design. So the term copyright is used, and in copyright we say piracy. So the same word we are using in we are using piracy for design too. Under Section 22, they are given that piracy, how can piracy happen? Means if some person is importing the designed products without permission, means without the authority of the creator of the design, and they are imitating his design over some other products. So contrib- this is constituting the piracy, and remedies available for industrial design are only civil remedies, no criminal remedies for designs. So the civil remedies are that they can get fine of 25,000 to 50,000 from the person who is the unauthorized user, or they can institute the case in the district court or the high court. Then they can also file a suit for recovery of damages. Layout designs of integrated circuits are vital in electronic and semiconductor industries as they define the arrangement of diodes, transistors, capacitors, and resistors, which are interconnected, and they perform the functioning in the circuit. The person, whoever is arranging these wires in these electrical components in the devices like mobile phones or computers or any other device which we use in our day-to-day lives, so this person is using his creativity, his intellect, to arrange these wires in a creative manner. He is investing his energy and his time while arranging this. So these designs need to be protected and prevent the unauthorized copying by others. We all must have done an experiment while we were studying in our high schools and the subject of physics, where we when been asked to do an experiment on resistors, voltmeters, galvanometers, etc. We were given three chances and we had to take three different readings at a time. So the same is done in the integrated circuits. Layout design is a blueprint of integrated circuit outlining where each component is placed and how they are connected to one another. These designs ensure that the integrated circuits functions properly and efficiently. We must have seen in movies many times when there is a terrorist attacks and the main hero or the heroine of the movie is kidnapped, or they are being tied with bomb on their body, and the main actor of this hero then comes and then he cuts down right wire, and this is how the bomb gets diffused. So we can understand that it requires intellect, energy, time to decide where to place a wire, where to connect it with other circuits so it works properly. And if something wrong has happened, means our arrangement is wrong, then it can result in short circuits too, which will harm to the people. So arrangement should be done in very effective manner and it requires creativity. So under IP laws, our creativity is protected. Eligibility for registration. The design must be original and it should involve creativity. In India, the layout design is governed by the Semiconductor Integrated Circuits Layout Designs Act enacted in the year 2000. Rights after registration. Registration is done to protect the layout design. The application for registration is to be filed with the Registry of Integrated Circuits and Layout Design. The application should provide the detailed information of the applicant, and he must attach with that application a sketch or the drawing of the design. And after registration, creator gets exclusive right to reproduce, distribute, or sell. Duration of protection. Once registered, the protection for the design is given for 10 years, and after 10 years the design enters into public domain, means that public can use the design and it will not amount to infringement or violation of the exclusive right of the creator. Common public can use the design without the permission of the creator. Infringement and remedies. In case of infringements, the creator can ask for injunction and damages. Injunction can be for permanent or for the temporary period, and the damages means he can ask for the accounts of profit that the unauthorized user has gained by using his design The challenge faced while protecting this design is that reverse engineering, where people can disassemble the circuit and they can learn how the arrangement is done and they can copy the same arrangement in their circuits. So it poses a challenge for protection of layout design.